Let me ask you something. Do you think the court reporter can take da 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 da, whoop whoop whoop
No.
down? Security guard is saying you caught him in the eye with your fingernail. Were you wearing those nails? Why was a girl behind your friend looking like she was going to hit her? What was going on? R3748, and this will be our last case. State of Texas versus DeAndre Deel. Can I have parties announced for the record for the state? Defense. And are you Miss Deel?
Yes, ma'am.
Counsel, have you received all of the discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Ms. Deel, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney?
Yes.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes.
Did you understand it? Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
We're proceeding on count one and waiving count two.
Any objection?
No.
All right, did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand in count one, you're charged with assault, bodily injury on a security officer? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe she has a rational as well as a factual understanding of the charges against her?
very much so.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Deel, did you review the document? I'm sorry, just 1 second. There's an email that's coming through for me. Ms. Deel, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state is proceeding on count one. There's a $400 fine, and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, we just asked for consideration as to the fine.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions? Outside the agreement, the state is recommending that your deferred adjudication be for a term of 3 years. There be a TAP evaluation, 120 hours of community service restitution, no contact with Benjamin Mendoza and Colin, Colin Johnson, anger management classes. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes.
Then to the offense as charged in count one, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State exhibit number one with all of its attachments. No objection.
State, you may be excused. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses, statements, and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review The same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court would defer finding the guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, please.
All right, so what started this argument at the Shoe Palace?
So it had nothing to really do with me. It was just me and a group of my friends. It was someone's birthday. We were just in the mall cashing out like $3,000 worth of stuff. So it was girls behind us. One of them got behind my friend and I told her, I said, hey, it looks like this girl is gonna hit you. Next thing I know, this girl did hit my friend. Mind you, I moved out the way. I didn't fight. I didn't do any of
Can I
that.
ask you this, please, so that just.
Oh, I'm so sorry. So we're just buying stuff up at the mall. One of the girls was behind my friend. My friend, I told my friend, hey, this girl is looking like she's gonna do something to you. The girl actually did hit my friend. So the people that I was with, everybody fought except for me. I'm on the sideline. You can see it on cameras. I'm on the sideline doing nothing. So I walk out of the store and we're all walking towards the exit. 7 or 8 security guards run up behind me and the guy didn't even give me a chance to say anything, do anything. He was aggressive towards me and I got scared. And I told him, hey, get out of my face, da 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 da, whoop de whoop whoop.
Okay, let me ask you something. Do you think the court reporter can take da 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 whoop whoop whoop
No.
down?
I'm sorry. No, ma'am.
So Maria,
Yes.
that's da 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 da. Whoop whoop whoop. And I may have missed one of the da 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 dots.
I'm sorry. So they just started, so the security man.
All right, so let me just tell you.
Yes, ma'am.
Security guard is saying you caught him in the eye with your fingernail. Were you wearing those nails?
They were longer and I'm sorry.
They were longer?
Yes, ma'am.
So it caught him in his eye.
Yes, ma'am.
That's why we're here.
And I do apologize about that, but at the same token, if 7 men was coming at you, you would be scared too. If 7 men threw you into an iron gate, you would feel the same way I did.
I would have picked up the phone and called the police
Oh,
if
they
I'm
was
at the Shoe Palace.
They were already there. That's the
Here's
thing.
my question.
Yes, ma'am.
Why was a girl behind your friend looking like she was going to hit her? What was going on?
They was hating on us.
All right, why?
Cause we was in the mall just catching up, just spending a lot of piece of change. That's a nice mall, spending some money.
Shoe Palace?
No, okay, well, I like shoes. I don't know about everybody else, but we spent a lot of money in the mall that day.
And which mall was this?
The one that's got the big boots on the outside of it that I'm not allowed to go back
Northstar?
to.
Okay. All right. You know what somebody said in a program that I watch? He said, wealthy people don't spend their money on fancy items because they're wealthy. They don't need to spend a lot of money so people can see that they're wealthy. He said poor people, some will never obtain wealth because they keep buying stuff to show that they're wealthy. Like I never understood when people would buy, like for example, the Hermes bag. That bag is like $20,000, maybe more, 120,000. Some of them, it's like people buy that bag, 120,000, poor people financially, and they don't have $20,000 to put in the bag. They like maybe have $100. But here's the thing: you got in a fight at the Shoe Palace, and the security guard got hit by your long nail.
I didn't.
If you would have, here's the thing: if you would have had your natural nails on, maybe he wouldn't have been injured.
Mhm.
But this is where we are. So the people you were with who are listed in here: Tahaya Lovejoy, Linda Marie Lovejoy.
Who? I don't know.
You don't know any of them? Okay. All right. This is what I'm going to do. Are you employed?
Yes, ma'am.
What do you do?
I'm an AGM for a management company for
I
hotels.
just wondering that.
An AG and assistant general manager.
All right. The court is going to sentence you to 3 years deferred adjudication. There's a $400 fine that will be probated. Do you have any children?
No.
All right. There's to be no contact with the following persons: Benjamin Mendoza, Colin Johnson, I think this is Tahiya, TA'Khiya, Lovejoy, Linda Marie Lovejoy, Tanisha Lauren Jones, Laurin. I know you say you love shoes. Not at the Shoe Palace anymore.
Okay.
So no contact with the Shoe Palace. And I tell you what, I'll do no contact at the Shoe Palace at Northstar Mall. Far be it from me to take away your ability to go to all the Shoe Palaces.
Okay.
So Shoe Palace at Northstar. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Anger management course. Regular random UAs. Field visits. One time per month for 2 months. Probation, is there anything else? Just 1 second. Probation? Is there anything else you need from the court to be successful?
No, but I have a question.
Yes.
So you said that there's gonna be field visits to, I'm assuming my home, which is cool,
Yes.
fine and dandy. I don't live in San Antonio.
Oh, where do you live?
I live in Killeen.
Okay. And she's gonna be out of Killeen probation.
Yes, sir. Regular reporting to June.
Yes. And transferred to Killeen, Texas. What parish is that?
Bell.
I'm sorry, county.
Bell.
Bell County? All right.
Probably from Louisiana. So I think
All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. You understand? All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue, let probation know. If you feel as though they're not addressing it, you can come back to this court and we can compare shoes.
Okay.
All right. All right. Probation will speak. Is calling 2024 CR 5014 State versus Waverly Whitlock. Can I have parties announced for the record for the state?
Megan Galloway for the state.
Orlando Castagnon for defense.
And are you Miss Whitlock?
Yes, Your Honor.
All right, Ms. Whitlock, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes.
Did you understand it?
Yes.
Are you the same Waverly Whitlock who was placed on deferred adjudication in 2024 CR 5014 for the offense of possession of a controlled substance penalty group 1 less than 1 gram on June 25th, 2024 for a term of 2 years? Is that you?
Yes.
All right, state.
Your Honor, the state wishes to proceed on violation of condition number 4 in Bexar County, Texas. The defendant Waverly Whitlock did then and there fail to report to the supervision officer as directed for the months of July, August, and September of 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State.
We waive and abandon the remainders.
Any objection?
No, Judge.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor. It is for the court to grant the state's motion, enter an adjudication of guilt against the defendant, revoke her community supervision, and sentence her to 90 days in the Bexar County Jail under 444 of the Penal Code.
That is our agreement, Judge. She has a very little criminal history. The only history that I'm aware of is actually this case and a misdemeanor that she was also under probation for out of the same transaction. She was approved to move out of state to Arizona, and she had really nowhere else to go. She moved and left them. She's ready to move on out of Texas. She in fact was living in New Mexico, and that's where she wants to return to and reside. And so she asked that you grant that agreement and allow her to return to New Mexico.
All right, what has she done on probation?
I'm not quite sure as to the extent of what she's.
All right, you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Waverly Whitlock.
Just out of curiosity, usually they take jewelry. So is your ring attached to your finger or what's going on?
It's attached.
Oh, you can't remove it?
Can't.
Oh my gosh. So is it that it's too small or there's something that you did? Because I know now people are doing those things where you can't remove the jewelry. So is it one of those situations?
I gained weight.
Oh, okay. All right. So what have you done on probation?
I did attempt to call and check in.
When you
but
say
I
you
didn't
attempted to
have-
call, what does that mean? Did you pick up the phone and call somebody?
Yes,
Who did you call?
I called the probation officer.
Which probation officer?
I don't know.
Was it Bear County? Was it in the other county?
In Bear County.
Okay. So how did you attempt to, so where did you obtain the number to call?
I'm sorry?
Where did you obtain the number to call the probation officer in Bear County? Right. So what else did you do? So you attempted to call. What else did you do?
That was it.
All right. So I don't
She
understand.
was hardly, I guess, on probation. I don't believe she was on
I
probation
didn't.
very long.
All right. So she hasn't done anything. I don't understand why I would give her 90 days, 1244. She hasn't done anything.
Well, so Judge, this would be a conviction on a record, and it would be something that it is a consequence of that decision. And so you're just asking that you allow her to accept that consequence and leave here in Texas.
All right. So the court will consider 1244, but I'm not considering 90 days for 1244. So if y'all want to talk about that, you can. Does anyone know how many days does she have?
She has
in?
90 days.
Oh,
jail time.
yeah, see.
Well, so I mean, it would be up to a year in Bear County Jail, Judge. So
This is what I will tell you, because you're telling the court that she doesn't have a record. This is a possession less than a gram. I will tell both parties, I will not go as high as a year. So if you all want to negotiate on a time, you can.
So Judge, our recommendation is 180 days for.
All right. Is that what you're in agreement to?
You okay with it? Okay. Yes, Judge.
All right. So my understanding, the parties have agreed to 180 days under 1244 at the Bear County Jail. Is that your understanding of the agreement?
Yes.
Are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal? All right, let me explain something to you. With the 180 days at the Bear County Jail, some people are like, oh, I'm supposed to get 2 for 1 or 3 for 1. I'm not in charge of that. The only thing I'm in charge of is sentencing you. Whatever, if they want to give you 2 for 1 or 3 for 1, that's completely up to the jail. The only thing I can say is I'm sentencing you to 180 days and they can't go over 180-day sentence. Do you understand? Now, what I can tell you is I'm not going to pick up the phone and call the jail and say, I want this person to serve day for day time. You understand?
Yes.
All right. Ms. Abrams, are you in agreement with revocation? All right, the court is finding violation of condition number 4 true. The court is going to grant the motion, find you guilty, revoke, sentence you to 180 days in the Bear County Jail under 1244. And let me just see if there's anything else that's due for your plea bargain agreement. All right, there is supposed to be money paid to Zachary Watson. Has that been paid? Was there any determination of a restitution amount?
Not that I'm aware of.
Probation, any determination of a restitution amount for Zachary Watson? State, I'm assuming that was something that was taken in consideration.
Yes, Judge, so she did, well, she had a misdemeanor burglary of a vehicle that she was also revoked on, and I believe that it was a condition in that case. Mirrored in this case.
All right, so the question becomes, have you paid anything to Zachary Watson?
No.
I'm gonna put in here restitution, if any, to Zachary Watson. Is there any objection?
No, Judge.
All right, and the reason why I'm including that is because that was a part of your plea bargaining agreement. So restitution, if any, to Zachary Tompkins Watson and cause number 729266. All right, is there anything else from either side with regards to sentencing?
Not from the state, Your Honor.
Nothing from defense.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. It appears that you may have drug problems. Don't visit those drug issues on your mom. You need to make sure that you get into sober support meetings. That's what they call the NAAA meetings now. Or if you need inpatient treatment, there are plenty of places that are free. If you can't find a place that's free and you need the help and you want the help, you can always come back here. I will, use whatever contacts I have in here to reach somebody in Mexico or Arizona or wherever you may be. But if you don't get a handle on this and control this, you're going to be picking up more and more cases, and you're going to look up and a majority of your life is going to be passed you by, and it's going to be in a haze. Because how you've been liking the Bexar County Jail. Yeah. So you got to remember that. Okay. All right. Good luck to
Thank
you.
you, Judge.
What started as a shopping trip at the mall ended with a felony assault case in court, a powerful reminder of how quickly a single confrontation can change someone's future. Throughout this hearing, the judge carefully walked through every legal step, ensuring the defendant understood her rights, the plea agreement, and the serious consequences tied to deferred adjudication. Instead of imposing an immediate prison sentence, the court chose to grant a second chance through 3 years of deferred adjudication, along with strict conditions including probation, anger management classes, community service, employment verification, and no contact orders. But it's important to understand that deferred adjudication is not the same as walking away free. If she violates the conditions of her supervision, the court can find her guilty and sentence her to as much as 10 years in prison without giving her another opportunity to contest the original charge. This case also highlights an important lesson about accountability. Whether the defendant intended to injure the security guard or not, the court focused on the fact that a security officer was hurt during the incident. The judge repeatedly emphasized that impulsive decisions and confrontations can have lasting legal consequences. At the same time, the sentence reflects the court's belief that rehabilitation is possible when someone accepts responsibility and follows the rules set by the court. Now the responsibility rests entirely on the defendant to prove that this opportunity was not wasted. What do you think about the judge's decision? Was deferred adjudication the right outcome, or should a harsher sentence have been imposed? Let us know your thoughts in the comments below. If you found this case as shocking as we did, make sure to hit that like button, share this video with others, and don't forget to subscribe for more jaw-dropping courtroom breakdowns, legal analysis, and real courtroom moments. Thanks for watching, and we'll see you in the next case.